Magandang araw po, si Kuya Bienyo po ito. Ang pag-uusapan po natin sa araw na ito ay ang Anti-Sexual Harassment Act of 1995, Republic Act 7877. Alam niyo po, ang batas na ito ay may kalumaan na, subalit hindi pa po ito naamendahan. At ito po ay masasabi nating napapanahon dahil alam naman po natin na ang ating mga estudyante ay bumalik na sa face-to-face mode of learning. Nagbalikan na po sila sa mga eskwelahan, sa mga institusyon. Ano po ba ang sexual harassment? Sexual harassment is the act of demanding, requesting, requiring sexual favor from another, whether accepted or not, by a person who has authority, influence, or moral ascendancy in a workplace, educational, or training environment. Ang pangalawang tanong po is, where is sexual harassment under Republic Act 7877 is committed? From that definition of sexual harassment, it is committed in workplace, in educational, or training environment. Now, where can there be sexual harassment? There can be sexual harassment when the offender and the offended party are related to each other as employer-employee, teacher-student, trainor-trainee, or other setup where a person has authority, influence, or moral ascendancy over the other person in a workplace, educational, or training environment. The next question asked is, who will violate Republic Act 7877? A person, male or female, may violate Republic Act 7877 by directly performing the prohibited act or by inducing, directing another person to commit it, or by cooperating in the commission of the prohibited act. Without such cooperation, it would not have been committed. Well, in this case, we have to take note that Republic Act 7877 is a malum prohibitum. That means the act is wrong simply because it is prohibited by law. That is why the law is very clear that it can be committed by direct participation, by inducement, or indispensable cooperation. Halimbawa po, yung teacher, he can directly commit sexual harassment by asking sexual favor from his student. Or he can also commit it by directing another person to commit it. For instance, a teacher has a friend. He asks his friend to demand, request sexual favor from his student. Or, for instance, a teacher asks his student to come over his place of residence to do some checking of papers. While in the place of residence of the teacher, a companion of the teacher made acts of sexual harassment. So in that case, the teacher can be held responsible for indispensable cooperation. Had the teacher not invited his student to come over his place of residence, it would not have been committed. How is sexual harassment committed in a workplace? Well, it is committed in a workplace when a sexual favor is made as a condition for employment, for hiring, re-employment, continued employment, or in providing favorable consideration, terms, conditions, and privileges, or by the refusal to grant sexual favor will result into limitation, segregation, classification of an employee in such a way that it would deprive, diminish his employment opportunities, or it will adversely affect his employment. Or if such acts of sexual harassment would impair his rights and privileges under the labor code. Halimbawa po, yung mga benepisyo ng empleyado, hindi ibinibigay sa kanya as mandated by the labor code dahil ayaw niyang pumayag doon sa sexual request from her. So, in that case, the offender will be liable for violation of Republic Act 7877. Likewise, the employer or the company can also be held liable for violation of the labor code. Another instance is that if that acts of sexual harassment will result into intimidating, hostile, or offensive environment to the employee. Halimbawa po, yung boss mo, day in and day out, lagi kang chinachansingan. So, mabuti sana kung type mo rin yung boss mo. Kung type mo rin yung boss mo at wala namang legal predicament, ibang usapan na yon. Worse is if you do not like your boss. So, your life will become miserable day in or day out. How is sexual harassment committed in educational or training environment? It can be committed against one who is under the care, custody, and supervision of the offender, or against one whose education, training, tutorship, or apprenticeship is entrusted to the offender. And such sexual favor is made as a condition for giving a passing grade, honor, stipend, allowance, favorable considerations, and privileges. Or when the sexual advances create an intimidating, hostile, or offensive environment for the student or for the trainee or apprentice. In this case of sexual harassment in educational or training institution, we have to take note of two things. First, there is the element of trust. And there is here the element of moral ascendancy. So, as we normally heard, the saying that our teachers are our second parents. Meaning, there is their trust, there is their moral ascendancy, such that if there is a commission of sexual harassment, it is understood that there is betrayal of trust and there abuse of moral ascendancy. Now, what are the obligation of the employer, head of office, educational, or training institution? They are obliged to address any complaint of sexual harassment. They cannot afford to tolerate any complaint of sexual harassment. Otherwise, under the law, they will be liable for damages. What are other obligations of the employer? Head of office of educational or training environment. They have to provide the necessary procedure to address, settle, or prosecute any complaint of sexual harassment. Alam niyo po, yung mga companies, universities, colleges, they have manual on sexual harassment. Ito pong manual na to, it contains all the acts that will constitute sexual harassment, corresponding penalties for violation of acts constituting sexual harassment, and the procedure to be observed in the hearing of complaint involving sexual harassment. Aside from that, Republic Act 7877 requires the creation of a committee on decorum and investigation, or CODI. This committee on decorum and investigation is responsible in investigating complaint of sexual harassment. And it is also responsible for information campaign regarding sexual harassment. The composition of Committee on Decorum and Investigation is representative in character. For instance, in a company, it is composed by a representative by the employer, a representative from a labor union, if there is any, a representative from the employee of supervisory in rank, and representative from rank and file. Now, the same thing in educational or training institution. There is the representative from the administration, representative from the faculty member, and representative from the students. The offended party may avail of the administrative complaint before his workplace, educational, or training institution. Or he may file a civil case for damages before the court, or criminal case for violation of Republic Act 7877. Now, what are the penalties for violation of Republic Act 7877? Under the law, the penalty is imprisonment from 1 month to 6 months, or fine of 10,000 to 20,000 pesos, or both, upon the discretion of the court. So what will be our parting words in this discussion? We just hope that the workplace, educational, or training institution will take seriously their policy of zero tolerance to sexual harassment, para po maiwasan na masira yung pangalan ng institusyon, maiwasang masira ang pangarap ng mga estudyante at ng mga manggagawa, at para maituwid ang maling mindset ng mga possible offenders of Republic Act 7877. So please subscribe and hit the notification bell so that you will be notified of my next video. Om Shanti.